Good morning and welcome to the panel on legal issues, strategies, and the role of the courts. I'm Craig Boyce, Dean of Syracuse University College of Law, and I'm a lawyer with a background in tax law. But as vice chair of the board of the Everson Museum here in Syracuse, in the last year or so, I've been plunged into the law around deaccessioning. The recent conversation around deaccessioning has been dominated by discussion of the standards of the American Alliance of Museums and of the standards and the recent relaxation of those standards of the Association of Art Museum Directors. The standards of both organizations are, of course, professional standards and not laws, except maybe in New York. And we promised that in this panel, we would step back from that emphasis and explore what laws are applicable, who enforces them, and how they affect the process and outcome of deaccessioning. Obviously, when it comes to state law, we're talking about potentially 50 different legal regimes in the US and more for those of you who are abroad, but there is some commonality among them. Two of those state regimes, Massachusetts and New York, are represented on our panel today by Courtney Aladro, Chief of Nonprofit Organizations and Public Charities Division in the Office of the Massachusetts Attorney General, and Jim Sheehan, Chief of the Charities Bureau, New York Attorney General's Office. And as a lawyer, I must emphasize that depending on where you're located, as they say in pharmaceutical and investment commercials, your results may vary. So we obviously can't cover the laws that are applicable in every jurisdiction. That's why it's wise to engage legal counsel in advance of a major deaccessioning. Accordingly, we've also asked Nick O'Donnell, a partner at Sullivan and Worcester in LLP, and Mark Gold, partner at Smith, Green and Gold LLP, to join us. Their years of expertise lie in navigating the often Byzantine law that applies to the activities of museums and nonprofit organizations. Courtney, Jim, Nick, and Mark, thank you for joining us this morning. Let's jump right into the discussion. Jim, within the New York AG's office, you're chief of the Charities Bureau. So describe for us what your charge is in that role. What is your responsibility under New York law with respect to museums and their activities?
I may go somewhat broader than New York just for clarity purposes. The responsibility of my office is to enforce the law as it is written and not as we would like it to be. As we'll see in this session today, one of the law that governs charities, including educational institutions, which are run as charities and museums, is primarily the sort of eight centuries later version of property law. And since the 1800s, the law both in New York and generally focuses primarily on donor intent. So there's a hierarchy of laws that we are called upon to apply and discuss and enforce. The top of the hierarchy in New York and Connecticut and some other states is the intent of the donor. So wherever the original work of art came from, the terms under which that gift is accepted by the museum govern what has to happen beyond any other consideration. And again, I'm not defending that as a policy, but that's the way the law is written in New York. The second aspect, you can stop me whatever you want, but the second aspect after the issue of what is the intent of the donor as articulated in the gift instrument is what is the mission of the museum or historical society. And in those circumstances, we have to look to the charter and other statements of intent, including the IRS 990. The third level of assessment is compliance with the regulations of the Board of Regents, which are very specific in New York, at least, at defining what those policies are. So in New York, the Board of Regents, which has a significant role in overseeing charities, as do we, that engage in educational activities, has essentially adopted the professional standards with respect to deacquisitioning and has defined what the proceeds can be used for. And part of our responsibility is making sure that officers and directors of museums recognize as part of their duty of obedience the responsibility to follow that particular regulation. But so that's very different from the way the world works, for example, in Pennsylvania, right? And there's a historic battle in the United States between the view that these are exclusively private institutions governed by gift instruments, and that they have the alternative view, which is Pennsylvania's, which is the courts and the attorney general have a very specific responsibility to intervene, to articulate and support a public interest beyond the intents of the donors. And so the Barnes Foundation is a classic example of how that works.
Right. Courtney, is that the way that it works in Massachusetts? Can you expound a little bit on your role and what you're charged with, as well as the law that you're charged with enforcing?
Sure. And thank you very much for having me here. My comments today, of course, are my own. They're not those of the office or of Attorney General Healy. Jim did a great job of describing the historic role of attorneys general across the country, and the laws can differ from jurisdiction to jurisdiction. Here our role is to oversee the administration of charitable assets throughout the charitable sector, and cultural institutions, of course, are an important part. And with respect to deaccessions, Jim had described the process in New York in terms of the Board of Regents, and we do not have a similar state law or regulatory corollary here in Massachusetts. But just as Jim had described, we do enforce fiduciary obligations, and we enforce donor intent and other charitable restrictions that may be on assets that charitable institutions hold. Because what our law supports here is not just what might be written in a gift instrument, for example, but also any representations that you have made to donors, how you as an institution have held yourself out to be. Those can result in charitable restrictions that also need to be abided by.
Okay, so then both offices and attorneys general in general serve an enforcement function for a set of rules or not in the case of Massachusetts. Yes, go ahead, Jim.
I think it's very important in this charitable sector that you use the term enforcement. I think a significant part of our responsibility is oversight and compliance and providing guidance to organizations on how to comply. So I wouldn't want to picture it as just the heavy hand of enforcement.
Okay.
And I agree with that. I think it's promoting transparency and accountability throughout the charitable sector. Sometimes that's through enforcement, and sometimes that's through the resources that we can provide to the sector.
I was intending to distinguish between that kind of role versus a policy-making role. And I take it that is not the role either of you have in this area, in this field, making policy. Is that correct? I think you suggested that earlier, Jim.
The primary responsibility of the charities bureaus in most states that I know, and I'll let Courtney speak for Massachusetts, is to apply the law as written. Now, there is a certain level of discretion for the Attorney General, not for me, in deciding what that oversight and compliance role should be. And if you look, for example, the Brooklyn Museum's collections policy, they've undertaken some fairly broad assessments of what preservation and care for the collection means. And they're at that level, there's probably a requirement of some interpretation on our part, but basically we have to enforce the law from 1601 and following as written.
So in the state of New York, for example, which I'm most familiar with, the New York Board of Regents has a set of requirements that museums must meet if they intend to deaccession a work of art. And it's worth pointing out that deaccessionings happen with regularity. I know we, over the last several years, have deaccessioned hundreds of pieces of art, things that were donated that satisfy the New York Board of Regents criteria for deaccessioning, and those include if the item is inconsistent with the mission of the institution as set forth in its mission statement, if the item has failed to retain its identity, if it's redundant, its preservation and conservation needs are beyond the capacity of the institution to provide, If you're refining the collection, importantly, those are all grounds that the Board of Regents statute permit deaccessioning. So if an institution complies with those, then is there a reason or a basis on which your office, Jim, would intervene in that deaccessioning?
So let me walk through three different things. So the first one is if there's a gifts instrument, or as Courtney pointed out, the course of dealing with the donor, which says you cannot deaccession it. And that's a decision that the organization makes, but since our job is to enforce donor intent, among other things, if that donor intent is clearly expressed, that overrides the deaccession policy. So you've got a white elephant on your property and you want it out of there, but you promised the donor you would never remove it. Too bad. The second issue is, what do your own policies say about deaccessioning? If they're stricter than the state regulation, you're bound by your own policies until you change them in the ordinary course. And the third question is, what are you going to do with the money? And I know that's been the subject of discussion already this morning, but we have to consider those three factors in assessing the deaccession activity of a museum or a historical society.
So, so is it a requirement that a museum in New York or Courtney in Massachusetts obtain approval in advance for the deaccessioning of items? And if not, how do these things typically come to your attention, to your purview?
I'm going to defer to Courtney on the Cypre process, which is one of those 8 centuries of incrustation, and Massachusetts even more so.
So we wouldn't expect necessarily every deaccession to come before us. It would, I think, depend on whether if it's a major deaccession move. A courtesy heads up would be appreciated. Certainly, if it's a deaccession and planned sale, that might run afoul of restrictions that might be on any of the pieces planned to be sold. That's what we would expect to be notified of. In terms of that CPRE process, if an institution holds collection assets, seeks to use either sell the piece and they're restricted from selling it, or use proceeds for another purpose that they believe they're restricted from based on those historical dealings with donors and what they've represented themselves as, then they would have to seek court approval in order to modify those restrictions and be permitted to do what they present to the court as being as near as possible to what those original restrictions are. This is a centuries-old legal standard that charitable institutions must abide by. It's an important part of the transparency and accountability that should happen with charitable institutions. And that required showing of, it's impossible or impracticable to continue to adhere to restrictions as they exist. Here's why our plan is needed. And this is what we're going to do with it. And this is why it's important to do it, and why it's as near as possible to those original purposes. A showing like that in many ways just makes sense. And with respect to any judicial petition that would be required, because of the historic role of the Attorney General's office with respect to charitable assets, we're a necessary party. So we would be a defendant in any petition that would be presented to the court. And that it's the court then that ultimately has that approval authority on modifying any potential restrictions.
And if I could, Dean Boyes, in responding to the question you asked inferentially, is it a good idea to let the Attorney General know? So let me tell you a bad idea. The Seward Museum in Auburn, New York, which is not far from Syracuse, in the middle of the night decided to remove a Thomas Cole painting from the property and ship it off to one of the auction houses in New York City. No prior notice to the community, no prior notice to the beneficiaries of the museum, not a lot of, and no public discussion. And the problem with that is it puts the Attorney General and the community in a very difficult situation. Much more effective to say, we're planning to do this. Here's what we think is our legal justification for it. What do you think? And then we may consent to the petition that gets filed with the court. We may say you don't need a petition, but very important, I think, to have that initial conversation in a major deaccession.
Great. So most folks in our audience are aware of high-profile, controversial deaccessioning transaction that took place in Massachusetts at the Berkshire Museum in 2018. You were retained as counsel for the Berkshire Museum in that transaction, Mark. At what point did you get involved in the case, and what were you asked to do? And what were your expectations for the involvement of the AG's office?
All right, so the Berkshire Museum went through a very complex 2-year expansive process of looking at their finances, looking at community needs, looking at their collections, their resources, all of those things. And during that process, I was brought in to talk to them about their fiduciary duties to the collection, to the museum, to their mission, and also talk about their legal, the status of the collection in terms of their legal options, including deaccessioning and sale. We ultimately, I explained to them also what they could expect from the professional associations and from the field. And I guess in the case of Berkshire Museum, I was working from precedent and prior situations of deaccessioning. So my appraisal of what would happen was a little bit less than what actually did happen. I think just to echo what Jim and Courtney have already said, I think we also gave a heads up to the Attorney General's office. And I think that's appropriate to do when they're in several occasions. One is certainly, as they've alluded to, if there's a restriction on the gift, they're going to just need to be involved. You're going to have to likely get court approval. The Attorney General is an essential party to that. So get them involved as early as possible if there's a restriction on what you expect to deaccession or sell. Likewise, there may be some other legal obligation to get them involved if there's a major mission shift going on. If there's a sale of all or substantially all of the assets, they would need to be involved in that. But the most important reason is you don't want them to read about it in the newspaper or hear about it from a disgruntled constituent or from the elected representative of a disgruntled constituent. But the museums deaccession all the time, and I think neither of them would wish to receive a notice from every museum that is selling something from its collection and to buy something else. So I think it's just a matter of, if it's going to likely be an issue, then I would certainly loop them in early on. And it also, as an advocate, it gets the story told on your basis. As for what I expected from the Attorney General's office, I was sort of wrong about that also. I'd been in the AG's office back not in it as an employee, but physically on their premises in 2009 during the Brandeis Rose situation. And for those who don't recall, Brandeis University was in really bad shape as a result of the financial collapse, and that it and a lot of its financial supporters were Madoff investors. They were looking at eliminating huge numbers of programs, shutting down dormitories, laying off, I think it was 40% of their faculty. And they looked at the time of selling the Rose Art Museum, the contents of the Rose Art Museum on the Brandeis campus. And I asked an assistant AG at the time, I was on there for an educational program. So what's the role of the Attorney General's office in all this? I mean, this is pretty high profile. And she looked at me and said, we just need to figure out if there are any restrictions or not. And, full stop. We're going to see if any of these gifts are restricted. Now, maybe she was wrong, but that had, she also added to that, well, we're not going to substitute our judgment for the museum board. And I think that's an interesting conversation to have at some place, as to, under their general investigatory and supervisory powers, how far will an Attorney General's office go into digging deeply into, was the board right or wrong in doing that? It was my understanding that boards were given great latitude in making those decisions. And I was a little surprised at the depth with which the Attorney General dove into the matter of the Berkshire Museum.
Yeah, thanks, Mark. Jim, coming back to to your reference to the Seward Museum and the Thomas Cole painting. Now, we have a question in the comments that wanted clarification around that situation. apparently that Thomas Cole painting, as I understand, was not owned by the museum. Actually, by a foundation, which in turn owned the museum. Is that correct?
It's that was a matter of some dispute within the. Well, let me just say it was a matter of dispute for many years. When I arrived as chief of the Charities Bureau, that the Attorney General already taken the position that the painting should be put back, and so the issue of whether the Emerson Foundation actually owned the painting or whether it was part of the Seward Museum, which was not owned by Emerson but was an independent museum under the New York State Regents, was never decided. And eventually, after a lot of discussion and review and learning about the provenance of the painting and also the condition of the painting and the ability of the Seward House as a facility to maintain it in terms of climate control and so forth, we agreed to allow that painting to be offered for sale. But it would have been a lot better, I think, had even though they had that argument, that is the Emerson Foundation had the argument, well, really, it doesn't belong to the museum, belongs to us. Better to have that discussion with us beforehand and say, this is why we think we have these rights. And if we disagree, let's go to court, as opposed to driving the truck up at 6 o'clock in the morning and taking the thing away.
Yeah, point well taken. So coming back then to the Berkshire case, Courtney, how did your office get involved in that transaction? Was it because this was noisy, or was there some standard review process that brought it to your attention?
So there was a notice provided to us, as Mark had outlined, of the Berkshire Museum's plans, and that does kick off a review for our purposes. The matter itself is pretty fully briefed on the ins and outs, but what was important to us and what the ultimate result achieved was that level of, not to keep ringing the same bell, but transparency and accountability that we expect from charitable institutions. And there were restrictions that we believed existed on the museum's ability to, existed on the particular assets that were planned to be sold. And we believed the museum needed to seek court approval in order to modify those restrictions. So ultimately, that's what occurred. There was, of course, a lot that went between an initial notice and that ultimate petition that was filed with the court. But we do believe that it achieved the right resolution there, which was, of course, from our perspective, driven by what the facts and the law required, what the facts provided and the law required.
Can I just respond to that very quickly for once? Because I think there was an interesting policy end to that too that I would love to discuss later, and that's the public domain. I mean, it clearly was an agreement by settlement, and the major piece of art ended up in the public domain, which outside of the state of Commonwealth of Massachusetts, which I thought was an extraordinary expression by the Attorney General's office of a more global, sort of an enlightened view of what public domain means from a state Attorney General's office. It was more important that it stayed in the public domain, even if it was in California, than that it might have achieved the highest dollar amount at an auction that would take it out of the public domain. So I think it was an interesting outcome. I think that is somewhat different in the state of New York, but I think it's a place where policy kind of overlaps pure application of the law. And that's not a bad thing. It's, I think there are a lot of people who would find that result appealing. And that painting is now still available for the public to see. So it might be worth later on talking about how some of those policy aspects play into decision-making and settlements.
So if there is no stipulation in the instrument of gift for a piece of art, no donor intent, let's say, then based on what you said, Jim, I think the answer is that you then move to the mission of the organization, the charter of the organization, the mission of the organization. So without donor intent, you move along from that that original inquiry to those next steps. Is that correct? We've gotten some questions in the Q&A about that. So absent any gift instrument or any contrary donor intent, then it becomes a question of the restrictions of your charter, in New York, at least, the restrictions of the charter, and then what statutes apply from the regions. Courtney?
The only thing I would add to that, at least from Massachusetts perspective, is that you look at the course of dealing too with the donor and the circumstances surrounding and the circumstances surrounding the gift, as well as the nature of the gift itself.
Can you say a little bit more about the course of dealing?
Sure. So if an institution has made certain representations to a donor, and a donor has made a gift, perhaps in part due to those representations, then sometimes that can lead to there being a charitable restriction on the gift itself, even if that was not necessarily memorialized in writing. And I think that you'd really have to look at all the facts and circumstances to assess that. But we do look sometimes beyond the particulars in the gift instrument itself.
Could I add to what Courtney just said? I agree with it. The authority for that is found primarily in what's called a MIFA in every state except New York, where it's called MIFA. And it defines it in terms of soliciting gifts of various types. It's not just the gift instrument, it's also what representations are made by the organization in order to obtain the gift. So if you say, once it's in our collection, it stays there. And that was part of the John G. Johnson gift in 1910. You're stuck with that, is our view. And the museum's record should reflect not just the specific gift instruments, but also the representations around major gift solicitation campaigns.
So, and that's interesting, because I think it would be less common for museums to actually solicit specific pieces of art. So are you suggesting then that whatever is part of a campaign statement would apply if those proceeds then were used to acquire?
No. Let's go. There's a fundamental distinction, at least in my mind, I'll let Courtney speak from Massachusetts, between solicitation of cash, solicitation of liquid instruments, and solicitation of specific objects.
Mm-hmm.
All right. So our view of restricted gifts generally in terms of cash under UPMIFA, NIPMIFA, is if you say we're going to use the proceeds of this to build a new building, unless you're the Catholic Church, which has its own rules, you have to use the money for the new building. If you solicit a donor for a specific piece of art, there's a negotiation usually about what you're going to do with it. Every donor of a specific piece, most of them want to believe it's in perpetuity. And the museum has an interest in saying, our collection grows and changes. And so for you, perpetuity is 75 years. I've heard that from one of our museums in New York. So I just want to make clear in this UPMIFA discussion that if you go to people and make the representation, it doesn't, as Courtney said, it doesn't have to be in the gift instrument. It can be part of that back and forth and is protected again by UPMIFA.
Nick, we don't want to leave you out here, and you're free to jump in at any time, but I do have a specific question for you related to the Berkshire case. You were involved in that case. Can you tell us how you got pulled into the transaction?
So I was hired by a number of people who were unhappy with the plan as announced by the Berkshire Museum. And we did a number of things. One was to communicate with Courtney's office, and another eventually was to try to stop the sale ourselves. And as the litigation played out, which has been written about much elsewhere, the court was not interested in our views from a perspective of standing as members of the museum. There was another group of litigants whom I didn't represent, so I don't speak for them, who were, among whom were either Berkshire County residents or descendants of the Rockwell family, as on the theory that there was a specific enforceable restriction to one of those gifts. And one exception to some of the things that Jim and Courtney have talked about is one can give a gift with an enforceable restriction on it. It has to be clearly articulated and accepted by the recipient at the time the gift is made. But as a matter of contract law, you can give a gift with a condition that trails behind it, which can be enforceable by you or by your heirs or anyone else, or not anyone else, but anyone in that lineage. And And so the Superior Court determined that neither members of the museum nor the donors had standing to complain about the proposed sale. The sale was enjoined on the Attorney General's motion by the appeals court until ultimately that was withdrawn and the CPRE petition by the museum was filed with the approval of the Attorney General. And there was a hearing before a single justice of the Supreme Judicial Court at which the opponents had an opportunity to make their comments, and the single justice ultimately ruled that the petition would be approved, and the sale went ahead.
So I'm asking this because we've heard that the AG's office really acts as in the interest of the public, and so I'm wondering about, in these kinds of deaccessioning transactions, if it's appropriate, if you think it's appropriate for third-party objectors to intervene, given that their interest is putatively represented by the AG's office.
Well, the question ultimately is what interest is represented and how is it represented? And at the point I got involved, my clients were not happy with the state of things. And at the time we filed the lawsuit, as I recall, the Attorney General had not taken a position publicly and had not publicly stated that the sale ought not to go forward. And so, out of concern that the sale, in the absence of an objection, would go forward, my clients did what they felt they had to do. So, what's appropriate, what's not appropriate really comes down to what you believe needs to happen. And there are certain tools available to us, and sometimes they work, sometimes they don't. In our case, my clients were not able to, standing on their own 2 feet, stop it. But certainly that intervention brought attention to it. The final result is the final result. But I think what constitutes representation of the public is a very important discussion to have. And who is getting to speak to that? How are those views represented or not? I'm not talking specifically about the Berkshire Museum case. I'm just saying in general, it's a sort of classic representative conversation.
Yeah.
If I could, Dean Boys, one of the challenges for the charities bureaus and the attorneys general generally is that, in fact, we don't, except for Pennsylvania and a few other states, we don't represent the public as a whole. We represent the interests of the undefined charitable beneficiaries. And that sounds like parsing words, but it's a very important part of the mission of attorneys general since 1601. And so part of that job is to make sure, if you look at many of our charitable institutions, including museums, take all kinds of actions. And there are lots of people who don't like those actions for a variety of reasons. So part of our role is to make sure we're there representing the interest of the charitable beneficiaries, but that the institutions and organizations don't spend all their assets fighting off a wide variety of people who have an interest in the outcome. I mean, an interest as a personal matter, but not have a legal interest in the outcome in terms of how the law is developed. And that balancing between, expressing the interest of charitable beneficiaries and making sure that it's not a litigation free-for-all is a balance that is defined by case law and statute, but also we take very seriously in terms of objecting to interventions.
So let's assume that we have a hypothetical art museum, and the museum is considering deaccessioning a significant piece of art. The board of trustees of the museum is aware of let's assume that they've made a call to the AG's office. Now they're thinking about their fiduciary obligations to that museum, and one of which apparently would be to obtain the highest possible price for that piece of art that they're going to sell. And we're assuming here that they've met the other criteria for deaccessioning. It's refining their collection. It's, for whatever reason, no longer necessary or core to the museum's mission. They think that the best way to ensure getting the highest price is to sell that art at public auction, but they've also received a private purchase offer that may significantly exceed what the auction might bring. How would you advise them in that case? Should they auction the piece? Should they do the private sale? Mark, what are your thoughts?
I think that's a classic dilemma, and my people I know in the auction business would say, no, you know, trust, and there's a lot of trust that goes on in the auction business, but in my perspective, all of the data is available to them, and not much of the data is available to the museum on which to make an informed decision. So in that, it's a heart-wrenching moment where you have to say, well, we could have X, we might get Y if we take it to auction. We really need Z, you know, and what do we do? My advice generally is the absolute safest bet in terms of fiduciary duty, discharging fiduciary duty, is to go to a public auction. It's transparent, it's visible. Everyone who's interested in it can bid, and that normally will bring the highest price possible. I think if you know, Baltimore is an interesting example because of the three pieces they were going to deaccession and sell. One of them was in a private sale. And I think if you have enough data and you have appraisals to back it up, and you know that this is a very motivated buyer who's paying an excellent price, then I think you have the documentation to discharge your fiduciary duty by having a private sale. It sort of brings up, this sort of fades into another interesting question that I think both New York and situations in New York and Massachusetts going on at the same time illuminated for me. And that was Berkshire and the Jamestown in Massachusetts and the Jamestown Library in New York.
I was just gonna get to that. I think
I can
it is a
do a
related
summary
question.
for the
Yeah.
audience if you want. So I remember the first time I met in Courtney's office, I was going through my usual pitch of, well, you know, we have to get, the board has to discharge its duty by getting the highest price possible in support of its mission. And one of her colleagues said, not necessarily, which kind of took me by surprise, and ended up, you know, eventually finding its way into the final settlement and judgment. And that is that I think most people would agree that the public auction of that particular painting probably would have received more for the museum than they got from a museum purchase or that kept it in the public domain. And at the same, so the Attorney General, in, I believe in Massachusetts, was saying that in some cases is a higher priority for us than you getting the most money that you can for it. At the same time, and Jim can tell me I'm wrong in my interpretation of this, the Jamestown Library, not a museum, a library, had a collection of paintings that they needed to sell in order to survive, common story, and they had consigned it to auction. And these paintings were very important to the town of Jamestown. And a group of citizens had offered to buy them at a known price, not an auction price, an agreed upon price, and keep them in Jamestown in the public domain. And Jim, I'm sorry if I'm misstating this, but I think the Attorney General's office said, no, in discharge of your fiduciary duty, your board, you need to take them to auction and get the most money that you can. So, you know, I think it's hard, you know, to give advice to a board as to, you know, I don't think any board on its own should decide to take less money to keep something in the public domain unless that is their mission. You know, and I think you need to get back to mission. And if your mission is to benefit the world and its access to art, you know, knock yourself out. But if your mission is to support your local community, getting less money for something by sending it to California or Arkansas would be, I think, a violation of that duty.
Let's turn to Courtney first. What was the thinking behind that decision to have the sale be to another museum at the expense potentially of a higher purchase price?
So generally speaking, I would say that that fiduciary duty would not require you to get the highest price if you are considering options that would keep it in the public domain to another public charitable institution. It depends on the facts and circumstances. It depends on what, if any, restrictions may have existed on the particular piece that you're looking to sell. There could be an additional reason that you may need to seek a higher price than what a public institution might be able to offer, depending on what your needs might be. So I think that while price is certainly a factor, and we would expect if it's a sale to a private entity, a for-profit entity, or particular individual, that there the drive is for the highest price possible. There doesn't really seem to be a reason to look at something lower. But if you're looking at public institutions and access to the public writ large, if that is a part of the institution's history with the particular piece, and that sale would contribute to addressing what the needs of the institution are, and this is all consistent with whatever the legal requirements might be, then exploring and considering public institution options would be appropriate.
Okay. Jim, what do you how would you respond with respect to the Jamestown case, the Prendergast Library?
Sure. So let me just say, I think that the process that Massachusetts went through with respect to the Berkshire Museum was appropriate, and as Courtney said, it looked to the specific mission of that museum, right? And I know Mark may disagree with me on aspects of that, but Jamestown, it wasn't an art museum, it was a library, and because New York State was, especially upstate New York, was relatively wealthy 150 years ago, and people donated art to their local library. And one of the challenges historically, is, at least since I've been here, has been, what do you do with that? They're very valuable paintings, but the core mission of the library is not maintaining an art collection. The core mission of the library is providing for the reading and media needs of that community. So one of the questions we have to ask generally is, what is the mission of the organization? And are you subject to the Regents rules and other rules in deciding how to deacquisition your, is it even an acquisition to begin with? Or an art collection to begin with. So that focus on mission is really important, the focus on the specific rules that govern it. But the other thing that Courtney talked about and Mark talked about, which I think is really important, is if your mission as an organization is public display of art and maintenance of the art collection, to me, speaking on behalf of the interest of charitable beneficiaries, which is my job, sending it off to a warehouse in Delaware to sit and not be looked at by anybody, seems to me, not that I'm going to, it seems to me to be inconsistent with the mission of the museum. And so I wouldn't say I'm going to make the decision for you, but I'd ask some relatively tough questions about why is this in the best interest of the charitable beneficiaries of your institution?
So I take it in this case, there was no donor intent that you could turn to in terms of whether that piece stayed in Jamestown or not.
No, there was not. As I understand it, again, it's as I understand it, no. Because that would have been the ultimate question, right? Without a sci-pri determination.
So that takes me to another question. When the AG's office becomes involved in these deaccession transactions, what is the scope of the examination that you can undertake? In other words, for example, in the Berkshire Museum case, there's pretty extensive investigation, and that was both extensive and lengthy into that transaction. At what point can the AG's office, would the AG's office ever, for small p political reasons, extend an investigation or I guess take a side in this if there were not clear-cut violations of the deaccessioning rules that applied? And either of you can answer that.
So I'd referenced earlier that the decisions of the office are based on the facts and the application to the law. And while there is certainly an element of prosecutorial discretion that attorneys general importantly have, those ultimate legal recommendations as to any claims that might be brought and an investigation that's pursued, that's all driven by the facts and the law.
Jim, do you have anything?
I agree with what Courtney just said. I think one of the things that happens in these cases is there are 100,000 not-for-profit organizations in New York, right? Not counting churches. So we have to decide, the Attorney General has to decide, exercising her discretion, not just what is the ultimate result we want, but to what extent should we undertake an inquiry or investigation? And I think one of the things that does happen is when you get significant public concern about an issue, we take a closer look to make sure that our initial assessment is correct. And that's different from deciding whether undertake a prosecution or to mediation or whatever. And so the first step may be affected by the fact that the Attorney General is an elected officer. But the second step, which is what do the facts and law dictate in this case, in my experience have been, that's how it works. That's how it's supposed to work, and that's how it works.
I would just add on to what Jim is saying. I think it's unrealistic to not acknowledge that the Attorney Generals are elected officers. And I think, under the umbrella of prosecutorial discretion, I think there's a lot that goes on. I mean, there were I don't remember Brandeis being subjected to the length and the intensity. LaSalle University in Massachusetts went through a deaccessioning about the same time. So I think Jim's point is well taken.
Pennsylvania, LaSalle, right?
Oh, is this there too? This is wasn't Pennsylvania in Massachusetts? Maybe not. Okay, regardless, there have been other deaccessionings and other activities that didn't engage this level of scrutiny. And I don't begrudge the office that level of scrutiny. It's within their discretion to do that. But I think we do have to acknowledge that the Attorney General is an elected officer. And within the realm of discretion, there's some movement to take more of a hands-on or a less hands-on approach, or to prolong things or dig deeply or not dig deeply. And I think Jim is right. The outcome might not be any different, but it's how you get there that's relevant.
So our hypothetical museum, we'll say, has provided advance notice to the AG's office in its jurisdiction that it plans to do this significant deaccessioning in light of several, and really did not receive a response, but in light of several strongly worded editorials and blog posts, the AG's office has decided to review the transaction. What are the options for the AG's office? And I say this to shed some light for museums that like us are navigating a process. Does the AG's office, obviously it could stop the sale. Can it require a particular kind of sale? Could it sue the museum? What are the tools that the AG's office has in these kinds of transactions? Again, Nick, feel free to jump in as well.
Did you want the AGs to respond, or did you want Nick to respond?
Yeah, all of the above.
So
Look,
what
I would speak for any Attorney General, because I am not one or in any office. And Jim and Courtney can speak better to the tools, but I mean, I think the critical question is going to be the way that the Attorney General or the Charities division of that state frames the concern, and what importance that office places on, as Jim said, the donor intent or the mission of the institution or whatever else. In the execution, that's the challenge, because results can vary pretty widely. I'm not here to relitigate the Berkshire case. I don't intend to. Right. But people can come to pretty sharply divergent views about whether that is in fact what's happening. And I think, an interesting example, first of all, the position the Attorney General is going to take is going to be dispositive, right? That's what's going to happen. And I think one thing that really bothered me in the wake of the Berkshire Museum is that when the Attorney General was asked about it a year or two later, she sort of waved it off, not Courtney, but the Attorney General, as, well, it was approved by the court. Well, it was approved by the court because her office came to a determination. A counterexample is what happened at the Corcoran, where the Attorney General of the District of Columbia basically got behind the merger with the National Gallery and with George Washington because of it's his view of what needed to happen in terms of the original intent of Corcoran himself, right, which was the public display of these objects in the District of Columbia. And so how that gets executed is going to really matter. And you can look at it in one sense and say that the Rockwell is at a public museum where it can be seen by the public. You can look at it another way and say, what good does that do anybody in Berkshire County? Any more than if it were in Arkansas or in a private collection that loaned it occasionally, I mean, in practical terms. So that's, that framing, those determinations are going to be what drives the result.
And that raises an interesting question. Maybe we can come back to after we hear from Jim and Courtney on this. And that is, what constitutes the public? Is that each individual, the public within the state where the museum is located, within its community, within the United States? What does community mean in this context? But Jim or Courtney, options, the AG's office in these cases.
Why don't I take a first shot, since Nick is not relitigating the Berkshire Museum case. The range of options, but understand in New York, and I believe in Massachusetts, we are advisors to the court. We're advisors to the court because we represent the interests of charitable beneficiaries. And Dean Boyes, you and I have this back and forth. There's public interest versus charitable beneficiaries interest. We think that they're different things. The public interest as a whole may say, do we really need art museums, or what are they good for, or should we have fewer of them? That's a public decision. The charitable beneficiaries, each museum is a creature of state law, a specific state, and has got its charter and says, this is what we're going to use our charitable assets for, and these are the beneficiaries. So that group is the one that we have to be, that group meaning we have to be conscious of and advocate for. And so let's do that. So then the next question is, how do we decide which of the many tools that we have to use in a specific case? And I'll run through a couple of them. So one of them is outreach, right? I read about a particular museum in Syracuse thinking of deaccessioning, and I pick up the phone, this is hypothetical, and call the director of the museum and said, I read about this, can you tell me the process you used to get to that result, right? And we have a discussion, and I see documents, and I recommend to the Attorney General that we take no further action. Or I say, great job, you did what you're supposed to do under the statute and regulations, and thank you. Second step is, where we may disagree about what they're doing, is again to pick up the phone and say, can you tell us how you got there? Let's have a meeting, let's figure out whether it complies with the standards of the regions. Third option is to open an inquiry and say, we want to look at your documents first, we send you a letter, and assess the transaction or the proposed transaction based on the documents. The fourth is subpoena, right? Send us all your documents, and by the way, let's look at the other parties to this potential transaction. And the final one, and the one we use most rarely, is litigation. And that means going to court and saying, the Attorney General's view, Your Honor, is that you should exercise your discretion to stop this transaction. So that's the range of tools, but I think the most important part for us is to have the conversation, to learn the thinking of the organization, to recognize the good faith of boards of directors and their advisors, and understand why they believe it's consistent with their mission and why it makes sense to take this action. And that's an important part of any good regulator's responsibility.
Courtney, anything to add on that?
No, nothing to add. I thought Jim said it well.
All right.
Craig, could I follow up on something Nick said? Because I think there's a part of this is the role of the courts, and it's also strategic. And I think it would be understating the effect that Nick had on this transaction in the ultimate result. And it was the private suits that came first from Nick and the other group of people. So the fact that it ultimately didn't succeed, it caused a very big shift in how the process went. It certainly cost the museum more money to defend these, but it also, the Attorney General is a required party in any action brought against a charity. I'm in Massachusetts. I'm sure that's the case in New York. And for these private plaintiffs, if that was their strategy, they succeeded to at least some extent. The Attorney General was brought in to litigation that she did not undertake, is you can correct me if I'm wrong on that, resulted in a hearing in the Superior Court, eventually resulting in an injunction, even though Nick's clients had no standing. An injunction ultimately issued that caused the sale to be postponed. I would say to the great harm of the museum, but it still caused a shift in how the process was taking place. So, I think if there are people opposed to these sorts of things, as Nick's clients were, somehow kind of the ultimate lack of standing doesn't mean there isn't any leverage and any ability to change what the outcome might be. I don't know, Nick, you may want to comment on that, but
Look, I think,
yeah, not to
and
relitigate Berkshire. But
yeah, look, I think it's more useful maybe to think in perspective terms. And I think everyone has touched on this, and that is, the more a museum thinks about and engages with what it is doing and why it is doing it, and engages with the people who might care about that result, the smoother it's going to be. And the Brandeis we haven't talked about very much, but when Brandeis proposed to sell the entire Rose Art Museum, it hadn't consulted with anybody. And I don't know to what extent Attorney General Coakley spoke to Brandeis or not. She was pretty discreet about to what extent the office was communicating with them. So I haven't the slightest idea what did or didn't make a difference. But the donors had no idea it was coming. So several of whom were still alive. So it was a very different situation than is often the case. And it was a disaster. I mean, it was a complete disaster of planning. And it didn't have to be that way. First of all, I mean, I don't think it should have happened at all, but it didn't have to be that way. And the board kicked the president out as a sacrificial lamb, which was sort of I don't know what to make of that. But I think by contrast, if you look at what the Everson has done or what Baltimore has done, I think I see those, or Brooklyn, I see those as fairly clear attempts to say, we are going over here. We'd like to do this because this is what we think is best for us to do. That doesn't mean there won't be people who aren't upset, but the more that's the plan and the strategy, I think the more likely it is to succeed, both from the standpoint of what you do and to the extent that's your mission, with a minimum of as Mark said, the expense to get where you want to go.
So we began by saying that there's this distinction between the actual legal standards and rules that apply versus the professional standards. And I want to come back to you with a question from the audience. So anybody who wants to comment, please do so. Will the loosening of the AMD's loosening of rules around the use of deaccessioning proceeds have an impact, do you think, on the way that AG's offices think about these things? Obviously you don't exist in a vacuum, but is this causing a rethinking?
Okay, I'll take it. I think the key here is how professional standards feed into the development of policy and regulation by agencies. And at the moment, what you have is for New York at least, is a State Board of Regents regulation that says X, right? And so you can't override that by having the American Association of Museum Directors change their policy. In addition to that, many museums of various types have a specific statement, both in their collections policy or in their bylaws or in their charter, that says we follow the AMD standards, both for collection and for deaccessioning. And so, as I said, part of our job is gift restrictions. Part of our job is you follow the law. Part of our job is, are you following your own bylaws, charter, and policies? And so the change in the AMD standard, if we're talking about that obedience to mission and so forth, means that with the change in the standard, the institution has more leeway in making decisions about deaccessioning.
Anybody else want to comment on that?
I don't think it changes the law, right? I mean, it can't. Right. And the Regents regulations have always been more flexible than the AAMD guidelines. I mean, Craig, you read out several of the provisions that would be permissible, and the concept of care and that sort of thing has always been part of the Regents regulation in a way that the AMD didn't countenance until the temporary rules last year. I think what it changes to this standpoint of the overall discussion of the trustees' fiduciary duty is the market is coming for this art, right? I mean, that's I think what I'm interested to see how the discussion plays out over the next couple of days. It took very little time for my phone to start ringing when that relaxed policy was announced. And that is because the art market is going to find the most efficient source of art to sell. That's what markets do. And what is going to happen to how we look at what museums are selling or not selling when those buyers are coming full force for these collections. And I don't think that's a question that can be answered yet. Because if you're going to say that the museum may and should, to some extent, use all of its assets to further its mission, well, then with that, which assets is it going to use? And how is it determining which assets that it didn't sell, and why not? Because I don't think they can have it both ways. I don't think they can say, trust us, this was what we needed to sell because this was the valuable thing. We're all set here. I don't think that works from the standpoint of either diligence or transparency. Now, I don't know how that's going to play out or not, but I think that's going to be the gorilla in the room for a long time because, like I said, this is now seen as a source of previously inaccessible art for sale, and that's coming.
And that raises the issue of the primacy of and the responsibilities of Board of Trustees.
Yeah.
I mean, it's their job to say this instead of that. And I would bet that attorneys general are not interested, don't have the appetite for saying, well, you should have sold the Renoir instead of the Rothko. I mean, that's just getting too deeply into what goes on in a boardroom. But I think, yeah, and the other thing is the whole purpose, the issue of existential threat. I mean, before the pandemic, existential threat to museums was the major employers leaving town, you know, looked at overwhelming debt at museums, whatever that was. And now I think AAMD has at least acknowledged that existential threat can be other things. So, you know, it's going to be interesting to see where the attorneys general come down on, you know, these are just standards, except in the state of New York. Boards know that. So they're not going to be able to get loans anymore. It's better to stay alive. But I think your point's well taken, Nick. It's going to inform those conversations.
Well, and I think the other part of that conversation is, to a point that was made earlier today, I tend to agree. I won't speak for an office I don't hold, but I tend to agree, right. The Renoir or the Rothko is probably a sort of business judgment rule level decision that's not appropriate to second guess if you have determined that the authority is there to do it. But what about the Renoir versus the colonial silverware, or the Renoir versus the, you know, indigenous this or that? And my point is, I don't think you can answer that question until you can say, as the institution, as a trustee, it's because we've looked at all of it and we've decided it's this and not that. But to do that, I think you need to do a lot more homework than has tended to happen to date in the deaccessioning debates, because it didn't need to. And that I think could put more pressure on the museums than perhaps they contemplate heading down this road, just from a resource and a time perspective.
Courtney?
So there were just two things that I wanted to emphasize that I think I heard the other panelists say. The first was that the change in ethical rules doesn't change what the legal rules are. It can change how you weigh as a board the different factors that you ought to consider. And in that sense, it might affect what the legal analysis is, but it doesn't change those legal standards. I think, though, too, with any change guidelines, that consideration should be made as to how, if at all, does that change your representations to donors right now and moving forward.
Okay. We have another question, a series of questions that get at this issue of does the passage of time, say decades, help in relieving a museum of must own and must display perpetually kinds of restrictions in gift agreements? Or restrictions that say you have to display these works together. Given the change in philosophy at museums about using works of different eras and collecting areas, are these kinds of restrictions just permanent without exception?
Why don't I take a shot? I'm sorry, go ahead, Courtney.
Well, the restrictions themselves are permanent. There is a court process that is available should an institution meet the criteria in order to modify those restrictions. And I think that you can look at the Isabella Stewart Gardner Museum, for example, as an example of this, right? There was the will of Ms. Gardner that laid out what the requirements are for that institution, and in a pretty detailed fashion. And there are times that the institution has gone to court to request certain deviation from some of what the requirements are through that will. But even though it's, I can't recall the exact year that Ms. Gardner had wrote her will, but even though it's been quite some time, those restrictions still apply today.
And I would point to the Gross Clinic in Philadelphia and to the Fisk University O'Keeffe collection. That those restrictions, even though they're ancient, and that's what property law is all about, are still binding unless you get a court to say that they're impractical or impossible to comply with.
So there are processes. The other aspect of this question is where records of gifts have been lost, whether there are no records. How do you navigate those situations?
With great difficulty.
Courtney, do you want to say a little bit more about that process you described?
Well, in terms of how do you navigate the question, a situation where there perhaps was not the level of record keeping that you would expect of an institution, I think sometimes that can raise some additional questions. Not just, doesn't usually end with, oh, okay, there, since you don't have any records, then the inquiry stops here. A lot of times it's more of, okay, well, what have you done to try to determine whether or not records exist? What went wrong in not being able to have maintained those? And sometimes this is from, quite some time ago, but in the end, certainly our office has been a party to petitions where the charity itself has sought to deviate from restrictions that might be there because, but there is no record keeping. And so accounting for that to the court in a public fashion through a petition can sometimes be a good conservative course of conduct. Not that it would always necessarily be required, but that has happened on occasion.
So we'll address one more question, and that is, we've been talking about artwork that we sort of assumed has been donated to the museum. But what about pieces of art that were actually accessed or acquired by the museum itself, and that do the same kinds of restrictions apply in those cases?
Go ahead, Jim.
Okay, so this is one example. We talked earlier about UPNIFA and soliciting money for specific purposes. So, for example, the man with the golden helmet, assume that you had had a fundraiser to buy that painting and said, we're going to put in the collection to keep there in perpetuity. So even though it was the fungible money that you raised, you made a commitment as part of the fundraiser that this is what you're going to do. I think today for most curators and development officers, they're smart enough to make sure that the language of that solicitation is such that that's not a problem. So they give themselves a wiggle room that's consistent with the curatorial policies. And is that sufficiently responsive?
Yeah, I think, in addition to that, though, if the museum just used its own revenue, not revenue that was donated for acquisitions or for, as Jim's saying, for a specific purpose, just said, oh, we collected from the people who came through the gate, we collected $100,000, we want to buy this painting, and 2 years later they say they want to sell it. My understanding is there's no problem with that whatsoever. There's no donor restriction on the painting. There's no donor restriction on the funds which were used to purchase the painting. You should be good to go. And yeah.
Assuming it's consistent with the collections policy and the deaccessioning policy, because the decision to add a painting or work of art to your collection is governed by your collections policy. And once it's accessioned, you still have to go through the back end of that, which is the deaccession.
Right. But there are no legal restrictions on.
Well, we're going to end there. I want to thank each of you for joining us today. This has been a very interesting discussion. I hope it's been one that's answered some of the questions that we've had from the audience. I want to thank our SU grad student, Derek Pratt, who's been helping out on the back end with getting questions to me. And I'll just close with a couple of housekeeping reminders. Remember that to join each session today and tomorrow, you must use the dedicated link for that session. And again, those links are in the symposium agenda. There's a little join here, orange box to the left of each session, and you can click that and join. And if you have any problems logging in, please email Carly, K-A-R-L-Y, at kmgproductionsny.com. That's Carly, K-A-R-L-Y, at kmgproductionsny.com. Thank you again, and we look forward to the rest of the symposium.